Thank you so much. Well, looking back, I guess it's part of my academic training. I did my undergrad at SOAS in London in Nepali language and politics, continued with a master in South Asian studies, and ended up doing a very interdisciplinary PhD on effectively how the 1990 Constitution of Nepal became so embattled that became the non-negotiable demand during the end of the People's War or the Maoist insurgency that became the prerequisite for bringing the Maoists to the negotiating table. So after that, I trained as a barrister in London, decided not to practice, went on and did a postdoc at the London School of Economics with professors Martin Laughlin and Conor Girty as my mentors. The interest continued, of course. It became more of a comparative constitutional law angle as I qualified and moved on from, in a way, from politics and acquired more of a comparative constitutional law angle. And the question, of course, was a fascinating one because my PhD fieldwork was in 2006-2007, so at the very beginning of Nepal's peace process in Kathmandu. So it was very, very interesting to see the Maoists emerging, so to speak, from the jungle and begin negotiating with the mainstream political parties with the making of the interim constitution in 2006-2007, so while I was on the field. And then to see the work of the first Constituent Assembly elected in 2008, that was dissolved in 2012, and then eventually the new constitution was promulgated on the 20th of September 2015, amongst protests, a lot of public debates, and political drama. So a lot of the questions that I started asking, in a way already during my undergraduate studies, continue to remain relevant, and not just for Nepal, but also from a comparative constitutional law perspective. Nepal tells a very interesting story with respect to the advancement of gender constitutionalism. On the one hand, Nepal has seen tremendous progress in terms of gender constitutionalism. So to give you a sense, the 2015 Constitution of Nepal contains an article specifically on the rights of women. It's one of the very few constitutions in the world that recognizes the rights of sexual and gender minorities. And that is the culmination in constitution drafting of years of successful litigation by women groups, LGBTQI plus groups in the Supreme Court, very much since 1990. The scope of a lot of this constitutional litigation by women and LGBTQI plus activists was to displace discriminatory laws in the Muluki Ain, which is the country code, and other pieces of ordinary legislation. So the textual result that we see in the Nepal Constitution in 2015 really is a testament to the work, very impressive work of activist lawyers, but also a testament to the response by the Supreme Court of Nepal that has been really quite courageous in a number of decisions concerning women's property rights, sexual violence, family law, equal treatment at work. On the other hand, with the many successes that we've seen, and one of the examples, one of the projects I've been working on, which is on sexual and reproductive health rights. And again, Nepal is one of the few constitutions in the world that contains specifically those rights. But on the other hand, and I think that's the negative side, picking up on your question, when we're looking at the limited advancement, what's the problem when we're looking at the 2015 Constitution? We're looking at the fact that it's a constitution that is unusual in containing, first of all, very specific provisions concerning citizenship, And if you look very closely at the text and the framing of the citizenship provisions in 2015, you start reading that part of the Constitution, and you have gender-neutral terminology in the way in which the earlier articles in that part are framed. Then, when we're looking at a specific situation in which it is a Nepali citizen marrying a non-Nepali citizen, then the question of gender is engaged. So suddenly we don't have a Nepali citizen and a Nepali individual. We have a Nepali woman or a Nepali man who's married to a foreign man or a foreign woman. And it is in that context, with respect to citizenship, that when foreignness is engaged, then the question of the gender of the specific Nepali individual comes to the fore. So effectively, what the 2015 Constitution of Nepal continues to enshrine is gender-based discrimination in the way in which Nepali men and Nepali women are entitled in passing on their citizenship to a foreign spouse and to a child conceived out of a union with a foreign partner. Why is it? And where is the connection between the constitutional framing of citizenship with respect to this gender-based form of discrimination and question of Nepali nationalism? So this is not a new provision that the 2015 Constitution enshrines. It's actually a legacy of earlier documents. When I conducted my PhD fieldwork interviews with some of the makers of the 1990 Constitution of Nepal, and I got to ask this question: why is it that a constitution informed by concerns about fundamental rights, about equality, in the context of redemocratization, continues to draw on obsolete forms of gender-based discriminations in matter of citizenship? And the answer was, in a way, geopolitical. A lot of the concerns surrounding the gender-based discriminatory framing of citizenship in the Constitution arch back to the issue perceived by a lot of the political elites in Nepal at the time with respect to the open border with India. So it's the question of cross-border marriages, and I quote from one of my old interviews: the scope of the provision was to prevent Indian men from acquiring Nepali citizenship in that context. So when we're looking at that blatant form of gender-based discrimination, which is a clear violation of international obligations that the Nepal government has contracted over the years, CEDAW, ICCPR, and that framing continues to prevail, and the government of Nepal is picked up on this violation of international covenants at the UPR, it's been picked up at the CEDAW committee, and so on. Why does that remain? Because it's a particular way of imagining the Nepali nation. And when we're thinking about nationalism, we tend to think about ethnicity, language. We don't think quite so much about gender. Of course, there is important political science literature on the question of gender and nationalism, historical literature. And I think that should be really brought to the fore of the legal analysis of this kind of provision. When we're thinking about gender in determining the question of belonging and structuring the idea of the nation, and what's the function of women specifically, and the reproductive capacity. And it's reproductive capacity of the nation. It is symbolic, but it also much more substantive when we're looking at that. So that is the connection between the constitutional framing of citizenship and the way in which the Nepali nation is being constructed in that very specific context of Nepal's geopolitical position. Using here the old adage by King Prithvinarayan Shah of Gorkha, who talked about and described Nepal famously as a yam between two rocks. The yam being the country of Nepal, and the two rocks being India and China. So it's interesting to have, and it's important to have a historically informed analysis of the constitutional framework, because it is only through that lens that we explain and understand the origins and the resilience of that gender-based form of discrimination in matters of citizenship. Thank you so much for your question. It's an excellent one that really goes to the heart of constitutional questions surrounding the meaning of the Constitution, optimal design options, but also, and most importantly, implementation. So I think the example that you give me, which is the constitutional treatment of the Dalit community, one of the most historically marginalized group within Nepali society, is really an important one to assess the life of the 2015 Constitution, especially since we're reflecting on 10 years of implementation of the document. So when we're looking at questions of design, and we're looking at constitutional instrument designed to redress anti-democratic injury, which is as rooted as long-standing as the forms of discrimination that the Nepali Dalit community has suffered over decades and centuries. What's the solution? Let's start with a descriptive analysis of what the 2015 Constitution does. There are different mechanisms through which a constitutional document can deal with forms of anti-democratic injury, historical forms of discrimination. So first of all, you have a question about rights. What sort of rights are protected in the Constitution? So when we're looking at the Dalit community, you have Article 24 and Article 40 in the Chapter on Fundamental Rights that explicitly prohibit any form of discrimination on the basis of caste, on the basis of untouchability. The Constitution mandates the criminalization, so punishment for these forms of behavior. And Article 40 goes further and creates affirmative action measures to uplift a historically marginalized group as the Dalit community. So, of course, when we're looking at rights, we need to connect the rights framework to mechanisms of implementation. And I'm going to come to that in a second. The second element is the question of political representation, linked to affirmative action measures. So we're talking about quotas. So what the 2015 Constitution does is to create forms of political representation, so effectively reserved seats, reserved position for particular communities that have been historically marginalized. So the idea is that through representation, so the idea of having members of a marginalized community have a seat at the table of decision making can really ignite change. So you have that in the political branches, so reserved seats in parliament at the three level, so at the central federal parliament, in the provincial legislature, and in local government bodies. You also have provisions in ordinary law that requires quotas for Dalits and for other marginalized communities in civil service, in the police, in the army, and so forth. So the idea is that change is incremental. So what the law does is to create an avenue for a marginalized community to have a seat at the table and for their voices to be heard. We know from studies, not just in Nepal, but in many other jurisdictions, that sometimes representation is not sufficient. And there is a question of political culture within these institutions that prevents the voice of marginalized members of marginalized communities, even if they have a seat at the table, to make a definitive contribution and to have a determining role in the decision that is being made. So, on paper, the 2015 Constitution, with its limitations, not a perfect framework, but it is a framework that seeks to redress explicitly those historical injustices. It's also a framework that in its declaratory parts contains the symbolism of social inclusion. So why is it then that we have enduring patterns of marginalization? And if we're looking at the Dalit community specifically, I'm citing here the findings from the excellent report that Amnesty International published in 2024 on the plight of the Dalit communities. And the key findings is a finding of state failure in redressing this historical injustice. So what is it that we're looking at? If I have to assess from a constitutional perspective the situation, on the one hand, the Supreme Court has been very clear and has consistently ordered the government and the legislature to pass legislation to enforce the rights of Dalits, but without a particularly effective result and commitment from the political branches. So what I'm saying is that these constitutional commitments have not translated in an adequate manner into changes on the ground. And that, of course, has two effects. On a very practical level, it means that the conditions of one of the most marginalized group in Nepal with very specific intersectional inequalities when we're talking about Dalit women has not made a change in the living realities of this community. And second, and the result of this situation on the ground is that you have a dented trust in state institutions and also in the constitutional framework and in the state apparatus, which is lamentable, especially in the context of a constitution like the 2015 Constitution of Nepal that was designed specifically to remedy these forms of historical injustice. Thank you so much. The question of Constituent Assembly failure is a very important one. We don't have so many examples, but I guess from South Asia, the case studies of Nepal and Pakistan provide important examples. Well, first of all, the question of failure has, as significant as it is commensurate to the significance of the mechanism of the institution of the Constituent Assembly. So what is it about Constituent Assembly that is so specific and so important? If you look at the great work that Professor Andrew Arato has done on Constituent Assemblies and popular sovereignty, he makes a really important point. Constituent Assemblies have such a symbolic meaning because they're considered the greatest embodiment of popular sovereignty in the exercise of constitution making. So, in other words, when we're looking at Constituent Assemblies, we're looking at the people coming together to craft the constitutions for themselves. So it is a question of sovereignty in the external meaning. So it's an assertion of the identity of the people vis-a-vis the rest of the world. But it's also a question of internal sovereignty. It is the question that it is the people coming together to give themselves a constitutional framework that will guide them into the future. So when we're looking at, and of course the comparison that I draw in that chapter is a diachronic comparison. it's not constitution making processes happening at the same time. We're looking at two South Asian jurisdictions, but in very different contexts. So, Constituent Assembly failure in Pakistan takes place in the 1950s with respect to the attempts of crafting the first self-given independent constitution, moving on from the Dominion Constitution that was granted by the departing colonial power in 1947. So the making of the Constitution by the Constituent Assembly was an important assertion of popular sovereignty. It was about crafting the identity of the nascent Pakistani nation. It was about creating a framework of government in what was essentially also geopolitically a very fragile context. In Nepal, when we're looking at the comparison, it's much later. We're looking at the failure of the first Constituent Assembly in the attempt of making Constitution number 7 in the country's constitutional history. And we're not looking at a post-independence transition, we're looking at a post-conflict. So Nepal is picking up the pieces institutionally as well, not just economically, politically, socially, from a civil conflict that lasted for 10 years. What these two experiences have in common with respect to the format of Constituent Assembly, of course the Pakistani one was not directly elected, and neither was the Indian counterpart, just for historical accuracy. But what they had in common was that they were going to draft the permanent constitution, and in a fragile transitional context. So what happens with respect of the dissolution? You had effectively tensions with the intra-elite tensions, both in Pakistan and in Nepal. You had the intervention of the courts. So the death, so to speak, of these bodies was the result of judicial decisions. What do we see in that as a result here? You see an enormous amount of political capital going into the work of these two bodies. And what you see in both of them is progressively these representative bodies being sidelined. Both of them, incidentally, were also functioning as legislature. So if you look at the work of these two bodies, they were splitting their work between the constitution-making body and the work of ordinary legislature. We can discuss whether that's significant or not, but what that double function signifies, and I think scholars disagree on the significance of that point, but what in my view that double function does is that ordinary politics becomes entangled with constitution making in terms of time, in terms of commitment, but also in terms of the manipulation of these bodies. So effectively, what's the significance of the fact that you have a dissolution that is legitimated by the intervention of the courts? You effectively have powers which are not, which are of course part of the constitutional machinery, but don't have the legitimacy from below that the legislature has in a parliamentary framework. So once that element is removed and the representative body is dissolved without being able to produce a constitution, that has enormous symbolic meaning, but also it means that the process is being derailed. It means that there are questions about how the new constitution is going to be made. It's a question of resources. It's a question of political capital. So I think that also dents the legitimacy of the constitution-making process. And I think what also these case studies have in common is that eventually the constitution has been made, but it's being prepared mostly outside. In the case of Nepal, I think you see the text of the reports prepared by the thematic committees being used, a lot of that has gone in, but there's also been very significant changes. And the significant changes that have been embattled have not been penned by Constituent Assembly members. And that is problematic because it's a question, first of all, of legitimacy. And that dents also the legitimacy of the Constitution once it is promulgated. Thank you so much. I think it's a very timely question, the one about constitutional change. I think the way perhaps that I would slightly rephrase that is a question about constitutional instability. And I think constitutional change is a way of responding. It's an effective way of responding, especially if it's systemic, to societal, economic, political pushes that the constitutional framework ought to accommodate. So let me be a bit less esoteric with respect to this point. So when we're looking at constitutional change per se is very good. For a constitution to survive, a constitution has to adapt to changing circumstances, whether those are economic, political, social. So you require forms of adaptation. So the constitution has to grow with the society in which it is embedded and respond in a dynamic fashion to those changes. When we're looking at constitutional instability and demands for change, or even constitutional replacement, which of course is a much more difficult sort of situation. Of course, constitutional replacement is a high-stake game. It's not desirable to replace the entire constitutional framework because it opens the polity to a state of vulnerability. And I think that's really why constitutional amendments, incremental change by the courts, responses by Parliament to ordinary legislation that has constitutional implications are usually considered more appropriate, lower risk options to deal with political pressures. So in a way, if we think about amendments and other forms of internal constitutional change that don't require replacement, we're really looking at a safety valve, a mechanism for the Constitution to preserve itself, to preserve its framework and guarantee a degree of continuity. I think also depends on the kind of regime. I think we can generalize some of those comments. So amendments are not just taking place in constitutional democracies. We're seeing a use of amendments also in single one-party systems like the People's Republic of China. There is really interesting work that is being done by Professor Ryan Mitchell at Chinese University of Hong Kong on this question, if you're interested in it. So when we're looking at, and I think your question points to a more complex situation as well, when is it that a constitutional system comes to breaking point? And effectively when amendments cannot accommodate. So let's use the case study of Nepal to reflect on some of those questions. How did the replacement of the 1990 constitution come about, for instance? Democratic constitution came out of a pro-democracy struggle. Again, not a bad document with glaring shortcomings, but it would have been a workable framework. The question there was political, and of course, the 1990 constitution as the legal form of a political settlement was not palatable to the Maoist. So when we're looking at the People's War that ravaged Nepal between 1996 and 2006, immediately in 1996, when the Maoists submitted their 40 demands to the government, one of their main requests in this list of 40 demands was one for constitutional replacement. A new constitution should be drafted by the people's elected representative. It was a question of process, so the way in which the constitutional framework has to be creative. But it was also a question of design. There were many features within the 1990 document that did not reflect, in the view of the Maoists, that actually captured the view of a sizable portion of Nepali society at the time, including the commitment to federalism, the commitment to secularism, devolution, recognition, redistribution. So the idea was that a new constitutional settlement was needed to enshrine those ideas. Nepal, again, is a good example of the high-stake game that constitutional replacement entails, because it opens a country to a situation of political vulnerability. And that is why it's considered a measure of last resort. The stakes are high because the gains are potentially high, but so are the risks. That's a great question. And I think, if we're looking at South Asia, the obvious example we start from is the Constitution of India. So first of all, I think when we're looking at the Constitution of India, we're thinking about the enormous political capital that the Constitution of India has with respect of the founding of the independent Indian state and the symbolism associated. And it's interesting that in a way is considered the first constitution of independent India, when historically that wasn't the case. But I think that kind of a collective amnesia about the founding moment, removing entirely the very few years under the Dominion Constitution, is really significant. Professor Rohit Dey has done wonderful work with respect to the Dominion Constitutions, and that's a question that he would be able to answer in much more detail, but that's a significant point there. Another example looking at Asia is the 1945 Constitution of Indonesia. Again, the association with the independence struggle and the constitutional birth of the nation is really, really quite important. When we're looking at flexibility, and again, we're going back to look at the Indian case, with the enormous amount of amendments, over 100, it's really been quite an important mechanism to see how that has contributed to the life and political relevance of the Indian Constitution. There are also examples that I think Japan, in that sense, provides an interesting contrast, where there isn't a culture of amendments. The 1948 Constitution was not an indigenous constitution, and there's a lot of very interesting literature. I'm thinking about the work of Professor Akiko Ejima on the Japanese Constitution as a founding moment, but of course, a constitution that is being often described as an imposed constitution, given the situation of Japan in the aftermath of World War II. So that presents more of a puzzle, considering that it wasn't an autochthonous constitution in a way, and also considering the dearth of amendments. Flexibility in general is considered good, and I'm gonna go back to my earlier point about amendments representing a safety valve for the system. There are also other informal ways for the Constitution to change and adapt to customary forms, to conventions, and so on. So the rigidity of the Constitution is not just to be found in its amendment provisions and the mechanisms of amendment. The rules matter, they matter enormously, but it's not the only area of constitutional law we should be looking at. Thank you so much. The transition that we see in Nepal is a complex and fragile transition. So by way of context, what we've seen in Nepal, actually on the eves of the 10th birthday of the 2015 Constitution, is been a wave of protests which have been named as, popularly in the media, as the Gen Z protests, that have swiped a lot of Kathmandu and a lot of the cities of Nepal, triggered by a social media ban, and in reality, really protest against corruptions, against the lack of opportunities, against the so-called, inverted commas, Nepo babies, and so on. The result of this protest has been, after dramatic incidents in which 19 protesters were shot by the police in Kathmandu, and many other casualties within 2 days of the eruption of the protests, led to the Prime Minister resigning, the dissolution of Parliament, and the creation of an interim government led by former Chief Justice Sushila Karki. Known for her integrity and very well respected Supreme Court judge who resisted impeachment attempts under a suspicious time, a judge that was courageous in pursuing corruption cases during her tenure on the bench, has put together a very interesting team in terms of the interim government with a number of well-respected professionals and public figures, and is stirring Nepal now towards elections next year. From a constitutional perspective, it is interesting that anti-systemic protests have coalesced in terms of political consensus around an institutional figure like a former Chief Justice, notwithstanding the fact that it's been a highly respected judicial figure. I think what I read into these political developments, recent political developments, is the fact that the constitutional framework of the 2015 Constitution, notwithstanding some sporadic demands for constitutional replacement and abrogation of the text, in a way has held its ground. That there is an attempt for what remains of the Nepali government, with many of the state institutions badly damaged, to operate within the blueprint of that constitutional framework. It's going to be difficult months ahead for Nepal, in which many courageous decisions will be required of this interim government and of government officials in state institutions at all levels, from the local level to the provincial level to the federal level. I think Nepal has seen historically different bouts of protest and arrest and constitutional instability. And I think what has prevailed has been a commitment towards constitutional democracy. And it is my hope for the country, but it is also my professional reading of the situation, that I think Nepal will sail through this difficult political phase, and in the hope that the demands for inclusion, for constitutional renewal that emerge from this protest will guide political decision-making in this very difficult phase. Thank you so much. There's been a lot of commentaries floating around, of course, within the Nepali-speaking sphere, but also within the English-speaking sphere. There's been a lot of excellent political commentaries. There has been an excellent Q&A by Ashish Pradhan at the International Crisis Group that I would recommend. An excellent piece by Nepali journalist Subina Shrestha for the Neyman Foundation, just to name a few. There has been courageous reporting. In terms of legal analysis, I have to say I've seen a mixed batch. There has been demands associated with Gen Z protests, but they're actually much older demands from fringe groups for a return to the monarchy. I find a legal analysis from scholars who have no expertise in the jurisdiction, and they go on to support calls for a return to the monarchy are not historically well informed. By way of context, Nepal has a long history of pro-democracy movements in which democratic forces clashes against the institution of the monarchy. We're looking at a royal coup in 1959 in which King Mahendra suspended a democratic constitution, imprisoned political leaders, and set up 30 years of panchayat rule in which political activists, civil society activists, suffered an enormous amount of political repression. It took another pro-democracy movement in 1990 for the constitutional framework to be returned to a constitutional democracy and a constitutional monarchy. Following the royal massacre that took place in Kathmandu in 2001, in which King Birendra and his extended family were killed, and the enthronement of King Gyanendra, his younger brother, what we've seen in the context of the civil war in Nepal is two bouts of monarchical autocracy in 2002 and 2005. So we're looking at an institution that, of course, was central to the development of Nepal's national identity because of the history of the country. And that is significant and, of course, should be readily acknowledged. But to support calls for the destabilization of the current constitutional framework with respect to the return of the monarchy would upend decades of political struggles and constitutional achievements. So I would encourage legal scholars to pick up some history books.